Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina, and today's topic is All Bundled Up, Making Antitrust Sense of Product Bundles and Clusters. So at a very basic level, we all understand, live, and experience what antitrust lawyers and economists like to call product markets and geographic markets. I need a widget to fix my toaster, so I go down to the local hardware store and I buy it. But we also all know that real life is a lot messier, as is the case with defining a relevant antitrust market. Today, we're going to discuss complexities associated with what have been referred to as cluster markets, products that are technically separate but logically analyzed together, and bundle markets, in a word, or, well, I guess a hyphenated word, one-stop shopping. Joining me today is my co-host, Sergei Zaslavsky. Hi, Sergei.
Hi, Christina.
So what are we talking about today?
So as you previewed, we're going to be talking about market definition, but not just your garden variety market definition, but about some special cases. Usually market definition is all about identifying products that are reasonable substitutes, but there are exceptions. Heart surgery is not a substitute for knee surgery. I certainly wouldn't want to go to a doctor that thought they were substitutes. But in some mergers, knee surgery and heart surgery may well be grouped together in one market. So we'll be talking a couple about these strange, interesting situations where we use something other than substitutability to define markets. And the two examples, as you mentioned, are going to be cluster markets and bundle markets.
Great. And who do we have to join us to talk about those markets today?
So we're very lucky to welcome Kevin Hahm to the program. Kevin has had a long and distinguished career at the FTC, most recently as the assistant director of the Mergers 4 shop. And Kevin is now in private practice as a partner at Hunton Andrews Kurth.
Welcome, Kevin. Good to have you on the show.
Thanks, Christina. Thanks, Sergei. Honored to be part of the discussion today. I'm a big fan of the program.
Well, it's great to hear, Kevin. It's great to have you on. So before we get to kind of the more advanced stuff, let's just get the basics out of the way. Could you tell some of our listeners who may be newer to antitrust, why do we define antitrust markets and how do we usually go about doing that?
Sure. So Christina already teed some of this up, but we're going to be talking about antitrust markets in merger cases. And so when you look at Section 7 of the Clayton Act, the language talks about prohibiting mergers that affect a line of commerce in a section of the country. So market definition is sort of the exercise of identifying the what and the where questions of that statute. And so as antitrust lawyers, we all know that the case law and merger guidelines require that we define markets. If you talk to economists, they'll often tell you this exercise is not really necessary. Ultimately, what we're interested in is analyzing the likely competitive effects of a merger. But going back to what we know as lawyers, we have to do that exercise. And in fact, when you're talking about merger cases, market definition often is the dispositive issue on a lot of these cases. I'd bet good money that the outcome of more merger cases have been determined on market definition alone than any other substantive issue. And in fact, right now the FTC is litigating a case against Arch Coal, where the big question there is, does natural gas compete with coal, for instance? So, that's the why. How do you define markets? It's Sergei, as you were talking about, it's about identifying reasonable substitutes for each other. And to get at that question about reasonable substitutability, you look at one, the extent to which buyers can substitute other products for each other, and then two, the extent to which prices of, say, product A are affected or affect the demand for product B.
That makes sense. So usually the game is about reasonable substitutability, but are there examples where something else guides market definition?
Right. So the two concepts that you guys already teed up are concepts where products are not reasonable substitutes for each other, but might get grouped together as either a cluster or as a bundle. And they are very distinct concepts analytically, and I think sometimes get conflated. But this is an issue that actually I've thought a lot about over the years, in part because of some of the industries that Mergers 4 covered at the FTC implicated sort of both of those concepts, both the cluster and the bundle.
And just for our listeners, what industries are those?
So some of a lot of what Mergers 4 did were hospital mergers, and that involves a cluster market. But we also did supermarkets, we did casinos, we did food distribution, which are all bundle markets. So we'll talk about a little bit more about all of those in a little bit.
Well, let's start with cluster markets then. Why don't you tell us what makes something a cluster market?
Yeah, so for cluster markets, we actually have some pretty good guidance from the courts based on some relatively recent cases, both the ProMedica case as well as the Staples 2 case. So the concept of clustering is about aggregating, multiple products where each of the individual service lines would otherwise constitute a relevant product market. Like you already had mentioned, Sergei, looking at hospital markets is really instructive here, right? So each service, whether it's a hip replacement or an appendectomy or a knee surgery, is a separate relevant market, and they are not substitutes for each other. And like you said, we'd have some pretty upset patients if they were substituted in. But the Sixth Circuit in ProMedica told us that, it could be a burdensome process to sort of evaluate each of the 100 markets separately. And so the court there endorsed the concept of clustering for what it calls analytical convenience. And the court also said that clustering would only be appropriate when the competitive conditions are similar across all of the services involved that you're clustering. So one of the issues involved in ProMedica was whether or not OB services should have been part of the cluster of the rest of the hospital services or not. And the reason why OB was separated out in that case, or at least the FTC alleged a separate market, was because only 3 of the 4 markets in town offered OB services, whereas all 4 offered all of the hospital services. And so the court agreed that sort of the competitive conditions there were different enough that it was okay to separate out OB services from the rest of the hospital services. But I think what's an important takeaway from at least ProMedica is that this process of clustering different services together, it's a permissive exercise. You don't have to do it. There's no requirement that you do it. But again, you do it because it's for administrative convenience for the court.
Yeah, there's a line in ProMedica that I really love, kind of helped me understand the concepts, where they compare cluster markets to a class. Like if different plaintiffs are sufficiently similar, it just makes more sense to combine them together in a class. It's convenient. And if different markets are sufficiently similar, we combine them into a cluster. Kind of similar logic there. I thought it was a very apt analogy by the court.
Yeah, that's exactly right. You're doing this sort of to ease the burden on the court and ease the burden of analyzing, otherwise hundreds of different services. Second case, go ahead.
Sorry, just at a fundamental level, is there a reason why you see certain clusters in particular markets as opposed to others? Like you could see benefits to having hospital overhead, for example, overseeing multiple practices. And so it sort of naturally lends itself to being a cluster market. I don't know if you have a view on that or if there's a reason why, competitive conditions end up being similar in certain markets and not others.
So the similar competitive conditions requirement really goes to, I think, sort of the number of competitors or sometimes, the entry conditions involved. And so, a good example is when you look at physician services, and this played out in the recent Sanford litigation, where you had different physician services, including primary care physicians, you had pediatricians, you had OBs, you had general surgeons. those were all pled as separate markets. It wouldn't have been correct to cluster those services together because they were such different competitive conditions that applied to each one of those services. So I think, going back to the hospital situation, there are a bunch of inpatient services that are appropriately clustered together. But then, when you look at hospital cases, for instance, outpatient services are not clustered in with inpatient services because entry conditions often are very different than on the inpatient side. A lot of states have what are called certificate of need requirements, and those usually only apply to inpatient services. The other recent case that gives us some guidance on clustering is the Staples 2 case. And I call this Staples 2 because there is a Staples 1 in 97. But the most recent one is in 2016. And this was a case about vendors that sold office supplies to large corporate customers on a business-to-business or B2B basis. Think about Fortune 100 companies that spend millions of dollars a year like McDonald's or Pfizer. So in that case, the FTC alleged a cluster market of consumable office supplies sold to these large B2B customers. And in that case, there was a really heated battle over whether ink and toner was properly excluded from the cluster of the rest of the office supplies sold to large B2B customers. And what the court found was that the competitive conditions for ink and toner differed pretty significantly from, the other office supplies because, there was this dynamic where you had large corporate customers that bought their ink and toner from printer and copier manufacturers like, Xerox and HP. You had Xerox and HP go into these customers to service their copier and printers. And at the same time, they were, selling these customers their ink and toner. So that was a reason for why ink and toner was properly excluded from the cluster. So that's sort of the current state of play on clustering.
And just to explain to our listeners a little bit, why does this matter? Why would a party spend, a lot of resources and a lot of time trying to argue that ink and toner is in the cluster market or not in the cluster market? What's at stake?
Right. So, this is what happens with a lot of these cases where, defendants are trying to get other services or products included into the cluster or into the product market because, it's because there was so much more competition going on the ink and toner side that, it would have lowered the overall market shares in the FTC's case. And it would have made for, a tougher case for the FTC. Same thing with outpatient services on hospital cases. If you were to include outpatient services in the cluster, not only would you be including the hospitals in the area that provide inpatient and outpatient services, you'd include all these, outpatient like ambulatory surgery centers that only do outpatient surgery into, the analysis as to who to count as competitors.
So the battle here is usually defendants try to get more into the cluster market, especially more products where they have lower share to lower the overall share within the cluster. And the government or the plaintiff tries to keep the cluster tighter to have higher share assigned to the defendants.
I mean, that's in keeping with the general theme of merger cases, right? The government tries to allege a narrow market, and defendants usually try to say, no, it's broader. But yes, you're right.
It's a variation on that theme. By the way, I'm really curious about Staples too. You were at the FTC during that case, and this doesn't really have anything to do with cluster markets directly, but there was a much debated strategic decision in that case where the defense decided to rest after the government's case and not put on their own case. I'm just curious, your perspective from inside the FTC. How did you guys react when you found out that the defense was doing that?
So I sort of shared the same reaction in terms of surprise, but in terms of a little bit of inside baseball, I also knew that had the defense put on their case and put on their own witnesses, I mean, there were a lot of great documents that we were prepared to show on cross-examination. There were probably some good, quotes from deposition testimony that we would have shown them as well. So I have to imagine that factored into the decision as to whether or not the defendants put on their case.
That makes sense. Okay, so we covered cluster markets. You mentioned the other category was bundle markets. What are those?
Okay, so this is an important distinction. So unlike cluster markets, which sort of group together a number of individual markets that would otherwise be their own relevant markets, a bundle market is the collection of products where the bundle itself is the market, right? So in bundle markets, customers often have the benefit of, as Christina talked about, one-stop shopping. And in some of these bundle markets, you see value-added services that are offered in conjunction with the bundle of products. So some examples of recent enforcement actions that came out of Mergers 4, that sort of capture this bundle market concept include supermarkets, casinos, and a bundle of physician services that were alleged in the United DaVita matter. So let's take supermarkets first, right? One-stop shopping is really a key concept. As you see in the FTC's definition, they talk about the ability for consumers to purchase substantially all of their weekly food and grocery requirements in a single shopping visit. And so supermarkets typically have substantial offerings of several categories, including, bread and baked goods and dairy products, refrigerated and frozen foods, meat and seafood, produce, boxed foods like cereal and sugar and flour, right? So you get the sense here that you're allowed, you think about it as the customer being able to go into this format and be able to obtain a bunch of their needs across different product categories. And the FTC also characterizes supermarkets as typically being 10,000 square feet in size and carry more than 10,000 different items. But, again, going back to whether this is a bundle or cluster, you can see why clustering these type of products doesn't really make sense, right? Your options for bread versus your options for fresh produce or meat are going to be different across those different product categories. So, that's a reason why you shouldn't think of supermarkets as a cluster. A second industry is casino services. So, this is another industry that should be thought of as a bundle. Casinos have been defined as offering a combination of table gaming, think blackjack, roulette, now poker rooms, slot machines and video poker machines, and then associated amenities like hotel, food and beverage, and entertainment. Now, where it gets a little interesting is when we think about bundle markets for casinos is we know that not all casinos offer all of the gaming offering options or amenities. So, for instance, in the Pinnacle Ameristar matter, one of the competitors in the Louisiana market was a combination of a racetrack / casino, or what's called a racino. And that competitor offered slots, but not table games. Similarly, in the St. Louis market, one of the casinos didn't have a hotel. And so I think this is where this sort of highlights the fact that, there's no bright line rule as to what services and amenities, a property has to offer to be counted as a competitor. But I think the lack of one of those services or amenities just simply goes to differentiation versus market definition. In that same complaint, that casino in St. Louis that didn't have a hotel was also described as a lower end first generation riverboat. There was another competitor in St. Louis was also described as a lower end casino with a small hotel and an RV park. So you can see that, whether or not this was a market definition issue or sort of differentiation in the competitive effects analysis, it really doesn't matter. And then the last industry I wanted to talk about was the bundle market of physician services in United DaVita. As I mentioned previously in the Sanford case, usually you would separate out physician services But in this case, the FTC alleged a bundle market of physician services sold to Medicare Advantage. And the name of these organizations that the FTC called was Managed Care Physician Organizations, or MCPOs. And the reason that MCPOs should be thought of as a bundle is really the whole is more than the sum of its parts, right? So think of MCPOs as groups that organize networks of providers for the purpose of coordinating care, managing utilization, and containing costs for MA population. And, a lot of these groups also have IT systems, sophisticated IT systems dedicated to managing, care utilization and monitoring patient care. So, one of my former colleagues at Mergers Force used to use the analogy of a contractor that you hire to build a house. You have the contractor, but the contractor is orchestrating and manages the work of all of these subcontractors to ultimately do that work. And so that's sort of how to think about MCPOs. So those are some recent matters involving bundle markets.
So interesting. So the intuition there is to be in the market, it's not just enough that you offer the same good. You have to offer the bundle of goods that customers are interested in being able to either buy the whole bundle or pick and choose from the bundle. As Christina said, one-stop shopping.
Yeah, and I think, an important concept here on the one-stop shopping is it's not necessarily that the customer is going to buy everything in the bundle that's offered. It's that they have the option or ability to purchase, 5 of the 10, elements of the bundle.
Has this concept been litigated in the courts at all?
Yes, it has. We do have a few litigated merger cases. And so, I think Cisco is a good case to talk about in terms of, what a court looks at in terms of, the elements of a bundle. So there, we're talking about broadline food distribution. And again, it shares a similar concept to the one-stop shopping as supermarkets. So when you think about broadline food distribution, think about these trucks you see delivering large quantities of food and related food products to restaurants, hotels, sporting arenas. This was the market that was involved in Cisco US Foods. And so the court there found that broadline distribution was a relevant market because, these distributors allowed customers to do their one-stop shop, to purchase most, if not all, of their food and related products. And, again, one of the big battlegrounds in this case was whether or not other outlets for food should be counted, such as specialty distributors, distributors that just did meat or seafood, as well as cash and carry outlets, that includes Costco and Sam's. And so the court noted that what distinguished broadline distributors was the product breadth and diversity, and that included, the offerings of both branded and private label products, but also some of the services involved that broadliners offered that weren't available from other distributors. And this included, flexible delivery, next day delivery, and menu planning. So, that was a case where, the court sort of looked at all, the whole panoply of services that the broadliners offered, that the customers were saying, yes, this is of value to me, versus, I can't get the same set of offerings from some of these other limited distributors.
Well, to let you, the listeners, in on a little inside baseball, Christina and I were both actually on the defense side on that case. So we might have to fight you about the market definition after the episode is over. But you mentioned there were several cases that were litigated about this concept. So why don't you tell us about the other cases?
Sure. So, what's interesting about this, what's notable about the Cisco opinion is that it cites to both the Staples 1 case and the Whole Foods case in its discussion of market definition. So Staples 1, again, this was the 97 version of that merger, was a case that was about retail stores, right? It was the stores that offer office supplies at the retail level, and whether there was a separate market for office supplies superstores. And the defendants, of course, were arguing that the market, which was much broader and should include, any retail outlet that sold office supplies, including grocery stores and mass merchants. So in that case, some of the evidence cited by the court that supported an OSS-only market included one, there were price zones that were based on the presence or absence of other OSS. There was pricing data that was presented that showed in areas where Staples faced no competition from other OSS, prices were 13% higher than where there was either another Office Depot or Office Max. Sorry, Office Max was still in the market back then. And then thirdly, Staples had changed their pricing behavior based on the entry of other OSS, but not other retailers. I think one of the really interesting parts of that case, the Staples 1 case, was Judge Hogan, who presided over the case, said, it's difficult to fully articulate and explain the ways in which superstores are unique. And so what he did was he actually went out and visited a bunch of different retailers in the Rockville, Maryland area that sold office supplies. He went to a Staples, he went to an Office Depot, he went to a CompUSA, Best Buy, CVS, Kmart, Giant, and a Walmart. And, after that trip, he said, look, the unique combination of size, selection, depth, and breadth of inventory offered by the superstores distinguish them from retailers. And the opinion goes on to say that this is really interesting. Superstores are simply different in scale and appearance from other retailers. No one entering a Walmart would mistake it for an office superstore. No one entering a Staples or Office Depot would mistakenly think he or she was in a Best Buy or CompUSA. You certainly know an office superstore when you see one, right? So that quote sort of has a similar flavor of Justice Stewart on his comment about obscenity and pornography, right? You know it when you see it.
I love that story. I mean, but that's what makes for a great case, when you have the economic analysis and it matches up with the real world data. So the judge there made sure, okay, I have the economic analysis, but does it match what I'm seeing with my two eyes? And in that case, it did. It's a great story.
And again, I think now that you see merger cases, there's a presentation of both quantitative analysis as well as this sort of qualitative evidence as well, which, going back to sort of brown shoe indicia, I think you always have to, sort of get the judge to understand what it is that makes this market, a separate market in and of itself.
That's great. And you mentioned that in addition to Staples, Whole Foods was also a case. Do we want to go into Whole Foods as well? Is there anything worth covering there that we haven't already covered in Cisco and Staples?
Yeah, I know we're running short on time, but the one thing I'll talk about in Whole Foods is, there was a piece of evidence that was presented that was called Project Goldmine. And this really was a gold mine for the FTC in terms of the evidence relating to competitive effects, right? This was a study where Whole Foods analyzed how many customers it would recapture if it closed a nearby Wild Oats store. And the recapture rates there were really, really high. And in several of those markets, there were several conventional supermarkets that were located in between. So it really went to, what economists do right now in terms of calculating diversion ratios. That Project Goldmine went to that recapture and diversion analysis.
So Kevin, one thing that I just think is interesting between Staples 1 and Staples 2 is I think within the industry, we sort of just think, oh, Staples 1 was for retail customers and Staples 2 was for corporate customers, but basically the same argument. But as you've illuminated today, there's real distinctions between cluster and bundle markets. Are they mutually exclusive? Can you have both of them? How should we be thinking about these going forward?
Yeah, great question. So, I think from a theoretical standpoint, are they mutually exclusive? I think the answer is no, they don't have to be exclusive. I think from a practical standpoint, the answer is probably, man, why would you ever want to allege both a cluster and a bundle? It seems like, there's already a lot of confusion as to the two concepts. Why would you try to introduce both of them at the same time? But I will say this, on the Staples 2 case, right, I think the the fact that ink and toner was such a big battleground, it sort of forced the FTC to allege a cluster market. Having said that, I do think that there was a lot of the bundle element in Staples 2 that was similar to the same dynamic that was going on in Cisco. You had these large customers that had very specific needs, and they valued sort of the one-stop shopping. I mean, that was clear in Staples 2 too. These large corporate B2B customers liked the fact that Staples and Office Depot offered all the office supplies in one delivery. It's just that because of the ink and toner, sort of, it would have been hard to allege that as part of the bundle. So, I do think that you can have both, but I think it's really hard to try to explain to a court, how both can be in play.
Yeah, exactly. I mean, as you illuminated in Staples 2, they made a strategic choice, and even if both could have been alleged. So, Kevin, this has been wonderful. But before we let you go, we always like to ask all our guests a couple of questions. First, if you could tell us something interesting about yourself that we wouldn't know about you if we just knew you professionally.
So, one thing that the only people that would know were people that were at my wedding was I sang a song to my wife by the Backstreet Boys.
Oh my
God. And I serenaded her with my brother who was playing the guitar and my cousin. And the three of us had scripted out these dance moves. And, we
I was hoping you were going to say that you did the dance too.
And we did the dance. But at the end of that performance, one of my uncles came up to me and said, you guys were so bad, you were good. So I said, I'll take that.
We would have done a video podcast if we knew how to dance. We're lucky we're not in video.
That you don't want to see.
Backstreet Boys was maybe this is aging me a little or not, was my very first concert that I ever went to. So I'm a big fan. And Kevin, what advice do you have for students or younger lawyers looking to do what you do and to have the career that you've had at the FTC and now in private practice?
So one of the things I always tell junior or even mid-level antitrust attorneys that they can make themselves invaluable to a team is just by digging in and learning the facts of a case, right? We all know as antitrust lawyers, it's so fact specific and fact dependent. And so, a lot of the things that drives the analysis is knowing, having a rock solid understanding and foundation of the facts. And so if you're an associate on the team, sort of responsible for a particular aspect of the case, let's take failing firm, for instance, if that's an issue in the case, learn all there is to know about the company's financial condition, know about its debt, its operating losses, its cash position, get to know the process for finding a buyer. When you become sort of the expert on the team on an antitrust case, you'll find yourself getting assigned to sort of meatier and more substantive assignments just sort of based on that expertise, and things sort of logically flow from that. And that's something where you're all on equal footing on every new case, whether, the most junior associate to the most senior partner, everybody's starting at square one in terms of the facts.
That's such good advice. I tell a lot to junior associates that, you're never going to know the law as well as a senior partner, but you have a chance to know the facts better. And in antitrust cases, facts really, really matter.
Absolutely right.
Wonderful advice.
So now to our final segment, what we like to call the Curious Hat.
And now it's time for the Curious Hat.
So in normal circumstances, we would have a physical hat that we would hand Kevin, and he'd pick out a number 1 through 25, and we would answer the questions or ask the questions on those pages. In current circumstances, we don't have a hat. But Kevin, if you could pick a number 1 through 25.
Let's go with 20.
So Kevin, what is your favorite movie?
My favorite movie? I have to say that A Few Good Men seems to be on cable all the time on the weekends, and I get sucked into that movie every time I'm flipping through channels. I get a kick out of Demi Moore's character saying, "I strenuously object." And also Tom Cruise's character saying, so this is what a courtroom looks like after his first courtroom appearance.
It's a great movie. It's like, I guess I don't watch cable too much anymore, but I used to watch all the 007. There would be a marathon of it, every Saturday or Sunday. I'm sure A Few Good Men is quite like that. And what actor would play you in a movie?
What actor would play me in a movie? I would say, so I have had people tell me that Chow Yun-fat I have a resemblance to Chow Yun-fat. He's a Chinese actor.
It's a great person to resemble. So, Kevin, again, thank you so much for your time today. This has been wonderful. And thanks to our listenership for listening in, and we will see you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.